I don't like pineapple, for example, and then I get this thing, right, and it's got pineapple on it. I actually like pineapple, but I know some people who don't like pineapple. And so then all of a sudden, there's a pineapple there, right? But if it was all digitally communicated that I didn't want a pineapple, it wouldn't show up on my hamburger, for example. So, anyways, we've all seen this is the problem is not new. All right, yeah.
Can you patent something that has to be published in a research journal?
All right, so now we're going to talk about some interesting things. It depends on, all right, there are a lot of rules on dates. And usually who I make answer these questions for me is my patent attorney at work. And so there's bar dates, right? Like you can go publish something in a journal, and then it depends on, what the journal was. Usually have a year to file a patent from the first day of publication. And some people use that to their advantage. Some people say, I don't want this to be patented, and I'm not going to make it, so I'm going to go publish it immediately, right? And I'm not going to file on it, but the publication links it to me, right? So now it's free to everybody, right? So some people use it as an advantage, and some people use it as a disadvantage. So there's like a year bar date, and I would really, if you're going to start asking questions about strategy and about timing of things, there's some excellent books. One is Patent Law Essentials by Durham. There's another one called Patent Writer. It's a very simple read.
But just to say, if it's published, it does not necessarily disallow you to not patent it.
For example, there's a famous case about the guy who invented the bra with the underwire, right? And he tested it on his wife, and she wore the bra with the underwire around for over a year. And then he went to go file the patent on it because it wasn't public knowledge, there was no public information of this. And the court came back and said, no, you can't patent that because it's been out for over a year. Now you can't have a patent, right? And so it's over a year now. Sorry, sir, you missed the bar date, and guess what? You can't have a patent on it. And like, this is not like a publication in a journal. This is under his wife's shirt. Right? I mean, it's a case-by-case basis, right? I mean, when you have these questions, you go talk to the people in the technology office about the rules, right? The patent lawyers love these questions, by the way. My patent attorney eats it up. Scott, I did this. We shipped it to the customer, and they used it, but right? And then, was it under NDA? Was it under a beta agreement? Was it how on earth would right? And then don't do that, Eric. You figure it out. But go talk to the people at the patent office. They know the rules. That's their job.
So if you develop something and then let's say you wanted to test it before you wanted to do a patent, you would have to test it for under a year and then try to apply it to the patent.
Not true. Not true. Hold on a second. He's talking. There's two different things that are going on. There's a public disclosure, right? And there's research and development in your private facility where you're not leaking any information out. There's two different things going on here. And so, by the way, you don't have to prove things work to file patents. It's kind of an interesting thing, right? Just go file a patent. Yeah, I don't know if it works. I don't know if it will ever work, but you don't have to test it. But no, all the time, people are working on projects, and the United States is first to invent. So if you go invent something, you put it in your notebook immediately. You sign it and date it. You get somebody who is usually not your boss or not directly on the project, because you can easily influence those people. But there's other people in the company who are smart, can understand the invention, and you have them sign that they understand the invention. And this signed and dated book is, an example is this is my notebook. This is one of my notebooks, right? And in here you'll find, I can't let you look at this one, but I've got things in here, and they're not all signed, by the way, but I have sketches and drawings that I put in here, and if I think they're important, I should be signing every page, by the way, but I don't always do it. And you sign and you date, and this is really important, because what happens is people go file patents, and we all file at different times. Sometimes we get the idea and we sit on it, we're fostering it, we're inventing, we're working on it, right? But we're first to invent in the United States, so I can go all the way back to my invention date instead, my priority date. Whereas another guy could 3 months later think of the idea, file a patent, and then it's going to go to a proceeding. Right? And they're going to say, well, who was the first to invent in the United States? In the European Union, gets easier, right? It's the first to file. Right? So, and there's arguments on first to event, first to file, and this is the grayer side of law, right? That these patent attorneys love to go fight these wars on who owns what, irrespective of the technology. By the way, they gotta win. Any other questions? There's got to be more. Yeah.
A lot of your process, you talk about having a patent within the structure of a company or a larger organization.
Yeah.
But if you have patents that are outside of that, do you have advice on protecting it and or whether or not you should try to share it with a larger entity, initial patents, so that you're not?
Yeah, you don't get beat up by this large corporate thing. So, one of the things I want to make clear before I leave, right, is I didn't throw out my disclaimer. I'm not a patent attorney. I'm not here to give you legal advice, but I can offer friendly advice, right? And the friendly advice is that it's really easy to go get a provisional patent. It costs $110, and if you have a disclosure form that you write on your own, and it's not part of UC Berkeley. If it's part of UC Berkeley, and you are part of this institution, then you must submit your stuff to UC Berkeley. There's no question, right? But if you are on your own, if you're not a member of the organization here, you're not using the computers here, you're not using the books here, you're not using. There's a lot of laws in this, right? So, that's up to you to go figure that out. But if you have things on your own, a provisional patent application costs $110. You can file it in 15 minutes. It will offer you some form of protection. Now, provisional applications, there's no claims provisionals. It's only specification. You only write drawings and show pictures, or make drawings and show pictures, or write specifications and have pictures. Sorry. And so you have to be careful. People get beat up by larger companies, right? I mean, likely you or I don't have the resources to spend $50,000 on a patent attorney, even if I'm winning. So, be careful. But there's good people out there too. Everybody's not bad. Organizations are not bad. And guess what? In America, we love the little guy. So, Godspeed. Go have fun and try to convince these people. And if not, right, raise hell. Find a newspaper. Reporters love to find news, right? I mean, there's other ways that you can beat big companies as a small person, right? And there are people who have written books on how to do this. So I don't have the title of the author offhand, but there is a guy who has a whole strategy on how to do this. I haven't read his book, but I've heard of his efforts. All right, it's 12:30, and I know you guys are dying to get out of here. So thank you for your time. Thank you for touching that. Stick around if you want to help out.